National Director of Public Prosecutions submitted into the civil forfeiture trial 2 affidavits signed by Caspar Hendrik Venter, which I call the impossible volume affidavit and the false formula affidavit, wherein both of these affidavits Venter has lied under oath. The first time that I read the impossible volume affidavit, I knew that Venter had lied. On page 4, in paragraph 6, Venter tells us that with the amount of chemicals found on the property, it would have been possible to synthesize 400 to 600 grams of methamphetamine. On the same page, in paragraph 6.1, Venter tells us that you need phenylacetic acid and acetic anhydride to make 1-phenyl-2-propanone. And on page 5, in paragraph 6.2, Venter tells us that you need 1-phenyl-2-propanone to make methamphetamine. When we go back to page 4, then in table 1, Venter tells us in line 2 that no acetic anhydride was found on the property. If you need phenylacetic acid and acetic anhydride to make 1-phenyl-2-propanone, and you've got phenylacetic acid, but you don't have any acetic anhydride, then you can't make 1-phenyl-2-propanone. And if you need 1-phenyl-2-propanone to make methamphetamine, but you don't have any 1-phenyl-2-propanone, then you can't make methamphetamine. Without disputing Venter's claims, a careful analysis of the information indicates that no methamphetamine could have been manufactured from the chemicals found. Venter wants us to believe that 400 to 600 grams could be manufactured from a collection of chemicals, one of which is missing. Venter may have been unconscious of his error, but whether conscious or unconscious, he has contradicted himself, which is perjury. This particular lie played a crucial role and was material in achieving the forfeiture of my properties. In the civil forfeiture trial, the National Director of Public Prosecutions was sitting with a problem in that the illegal search did not uncover any illegal drugs or any incriminating evidence of any kind. In order to circumvent the absence of a crime, the National Director of Public Prosecutions desperately needed to invent a volume of methamphetamine, and Venter's volume lie proved to be indispensable. Johann Smit, in paragraph 8 of his affidavit, repeats Venter's 400 to 600 grams lie as though it were a confirmed fact. And then in paragraph 9, Smit values 500 grams of Venter's non-existent methamphetamine at 250,000 rand. Venter's volume lie appears in 6 affidavits and 2 submissions and were vital for the National Director of Public Prosecutions to build a case against me. Paragraph 6 of Venter's affidavit, paragraph 8 of Smith's affidavit, paragraph 7 of Adams's affidavit, paragraph 57 of Mop's affidavit, paragraph 12.5 of Mrs. Rubaji's affidavit, paragraph 13 to Annex MTK4 of Kaji's affidavit to the High Court to force my eviction after I refused to leave my home. Paragraph 52 of Trengrove's submissions, paragraph 662 of Breitenbach's submissions. Venter's volume lie appears in paragraph 38 of the Supreme Court of Appeal judgment, and in the judgment of the Constitutional Court, Venter's lie appears in paragraph 12 and in paragraph 23, with Smith's false value claim reappearing in paragraph 65. Venter's lies found their way into mainstream media, where visibility was ensured with front page articles which guaranteed readership in the tens of millions of people, and my dignity was smashed to smithereens. This massive publicity campaign was orchestrated by the National Director of Public Prosecutions to use me to promote its Prevention of Organised Crime Act. But in its greed for visibility, what happened is that Tick became a household name. When I was arrested in 2001, no one on the Cape Flats knew what methamphetamine was. In paragraph 30, Erasmus favorably advertises methamphetamine to be a drug, and let me quote, that is relatively easy to manufacture and thus is ideal for production in clandestine laboratories in residential areas. Talk about being irresponsible. There's no other way to interpret the practical implications of the statement other than Erasmus has endorsed this crime, and by so doing, Erasmus has informed and invited the criminally inclined to engage. From the newspaper, we have Hendrik Westraat of the Drug Police informing us that since the start of the civil forfeiture trials in 2001, methamphetamine drug abuse exploded by over 7,500%, which confirms that contrary to having prevented this crime, the National Director of Public Prosecutions has been the single most influential factor for the escalation of methamphetamine, the explosion of which coincided exactly in line with and in step with the advancement of the civil forfeiture trials from Erasmus all the way up to the Constitutional Court in 2006, when Westraat submitted these statistics. If I had been working secretly from my garage to promote methamphetamine drug crimes, then I could never have achieved what the National Director of Public Prosecutions has succeeded in doing. Following my arrest, I was imprisoned in the cells of the Woodstock police station. And before the drug police had taken me to court to be informed of the charge, the Cape Times newspaper published several lies about me. Regarding the chemicals, Rian Reddinghuis states that 1 kilogram of non-existent methamphetamine could have been manufactured, which contradicts Fenter's 400 to 600 grams. Reddinghuis then values his non-existent methamphetamine at 700,000 rand, which contradicts Smith's 250,000 rand. When we do the arithmetic, then we discover that Reddinghuis values methamphetamine at 700 rand per gram, which contradicts Smith, who values methamphetamine at 500 rand per gram. In paragraph 653 of Fenter's false formula affidavit, he values the industrial chemicals found in my home at less than 3,000 rand. When we do the arithmetic with this number, then it means that according to Reddinghuis, 3,000 rands worth of industrial chemicals can be converted into an unbelievable 700,000 on the black market. Who are we to believe? These lying drug police are not talking about something that exists in real life. They are talking about bogus, made-up stories, and that is why we have the contradicting statements. The one liar never took the trouble to check on what the other liar was saying. We can take it as a given that all three of these drug police are lying. Johan Schoener published the Reddinghuis lies, which guaranteed for me to be condemned by public opinion, even before I had appeared in court to hear the criminal charges. Reddinghuis was not in the civil courtroom to explain himself, but then neither was Venter nor Smith for them to explain themselves. The National Director of Public Prosecutions didn't bring any supposed to be witnesses into the civil courtroom and came armed only with pieces of paper which in criminal matters is deficient, whether or not these three lying drug police were present in the civil courtroom, they are all representing the same drug police department that filed the criminal charges against me. So the contradictions emanating from these three drug police deserve equal consideration. The drug police department put Redlinghuyse up to his mischief in order at an early stage for me to be seen in a bad light. And even before the beginning of either my two criminal trials or the civil trial, these false claims of Redlinghuyse served to set the stage for me to be perceived as being a dangerous menace and to encourage for me to be treated harshly. My bail hearing was the day after this article was published, and it is my reasonable suspicion that the Redlinghuyse lies did influence my bail being set at an unusual and exorbitant 20,000 Rand, which I think at the time, back in 2001, was enough money to buy a house in the Cape Flats. My bail conditions also restricted my freedom and confined me to remain within the boundaries of the Cape Town municipality, and I had to sign at the Woodstock police station between 5 and 7 p.m. every day. Bearing this in mind, it is fair to keep Redlinghuyse in this discussion and include his contradicting statements to support my charge of perjury against Venter, and more so especially since Venter and Redlinghuyse were both in the employ and under the control of the same drug police department. We have Venter's unconscious conflicting submission regarding the absence of a sitting and high ride, which forces us into the only rational and logical conclusion that no methamphetamine could have been made from the chemicals that were seized. Based on the available information, it is an indisputable fact that the exaggerated numbers being put forward by the drug police are not true. The National Director of Public Prosecutions called upon Carl Mop to use Venter's volume line and to use Smith's made-up value story of 250,000 Rand to fabricate a criminal case against me in order to get my house. The National Director of Public Prosecutions has embroiled itself into a legal fraud by seizing upon these particular lies to convince the court that the forfeiture was not disproportionate to the crime, because the value of Venter's non-existent methamphetamine exceeded the value of my house. Subsequent to Erasmus having deprived me of my home in the second criminal trial, case number 16-23603, the oral testimony of Johann Smith, who was the arresting officer, confirmed to the criminal court that the illegal entry of the drug police into my home did not uncover a crime. Magistrate Leroux asks Johann Smith a direct question. You find all these substances in his garage, it's in his home, and he hasn't manufactured any illegal drugs. Can you charge him for anything? And Johann Smith replies to say, no, no way. Whenever any action cannot qualify for an arrest, then it follows, and it is logical to conclude that the same action cannot qualify for a conviction. The National Director of Public Prosecutions has lied to the Supreme Court of Appeal and has also lied to the Constitutional Court to say that I was acquitted on a technicality. This disclosure came before the search warrant had been set aside, so don't anybody try to tell me that I was acquitted on a technicality. Being found in possession of over-the-counter industrial chemicals does not constitute a crime under the Drugs and Drug Trafficking Act. While non-derogable law was firmly urging for the incontestable presumption of my innocence, and before I'd been found to be not guilty, and in the absence of a crime, the National Director of Public Prosecutions needed a volume of methamphetamine to produce an apparent argument that would give some sort of credence and permission for the National Director of Public Prosecution to dodge constitutional law. Carl Mop's affidavit would not have had the same punch without Smith's 250,000 Rand derived from Venta's lies. Both the volume and the value claims are nothing more than fictitious, made up stories which have been submitted under oath, which constitutes fraud. The National Director of Public Prosecutions presented these lies into the civil court in a way that appeared to be factual. And unfortunately for me, the civil courts were tricked into believing Venta's lies. And as a result of these lies, I was condemned. I was waiting for the criminal trial where I was going to ask Venta to make methamphetamine from the chemicals and the equipment seized, because I knew that it would not have been possible. Because not only were the required chemicals missing, but about something that Venta doesn't touch on, a lot of the laboratory apparatus that was essential in order to complete the chemical procedures was also missing. It's easy to come into a place and they say that something can be done, but it's another thing entirely to actually do it. Unfortunately for me, and luckily for Venta, the criminal trial ended in a way that I did not expect. And I lost an opportunity to be able to force Venta to basically testify against himself and provide the proof beyond a reasonable doubt that Venta has lied under oath to the civil courts. When Venta broke into my home, he did not find me manufacturing methamphetamine. What he found is that I'd been chained onto the burglar bars in my lounge by his colleagues Grimbacher and Smith. Venta's ramblings about what I was supposed to be doing are unconfirmed assumptions, but into his speculation. And speculation is all that it is. He has lied about how I was supposed to be making methamphetamine. In paragraph 8.1 of Venta's false formula affidavit, according to Venta, one of the ways to make methamphetamine is by adding 1-phenyl-2-propanone with chilled methylamine. And according to Venta, this is what I was supposed to have been doing. To reinforce the lie, in paragraph 8.5, Venta tells another lie to the court, that combining 1-phenyl-2-propanone with chilled methylamine would exclude the possibility of any other resultant substance but methamphetamine. This is a second contradiction, which automatically opens Venta up to another charge of perjury. On page 5, in paragraph 6.2 of the impossible volume affidavit, Venta gives us a different version of what happens with these chemicals, where he tells us that 1-phenyl-2-propanone and methylamine gives us informal methamphetamine. I'm going to set aside Venta's guesswork, and I'm going to do a real-life demonstration and pursue Venta's speculation about what he says that I was supposed to have been doing, which according to Venta is that I was going to combine what he says he found in the toilet with what he says he found in the fridge. I'm not agreeing with Venta that he found what he says that he found, but for the sake of not being argumentative, let me put that issue to one side. To avoid unresolvable arguments, I'm going to combine 1-phenyl-2-propanone with chilled methylamine in front of the camera so that we can find out whether or not we get informal methamphetamine or if we get methamphetamine. I'm well aware that people might be saying that the chemicals in this video are not what I say they are. But if you don't believe me, then go and purchase 1-phenyl-2-propanone methylamine, chill down the methylamine in the fridge as per Fenter's instructions, and then conduct the experiment for yourself. You'll get the same result as is being demonstrated here. No conversion to methamphetamine follows, and neither is there any conversion to N-formal methamphetamine. All that happens is that the 1-phenyl-2-propanone floats on top of the methylamine, and the only reaction that occurs is that eventually the chilled methylamine warms up to room temperature. 1-phenyl-2-propanone is an oil-based chemical, and it's not going to combine with methylamine, which is a gas at room temperature and is sold as a liquid with the methylamine suspended in a solution of water in the ratio of 40% methylamine and 60% water. It is scientifically impossible to combine these chemicals, as Fenter tells us, for a reaction to occur that causes any conversion into methamphetamine or N-formal methamphetamine. Adding formic acid to the solution will not resolve the oil can't mix with water problem. Fenter's lack of detail means that he doesn't properly understand what he's trying to present, and he's talking rubbish in both of his claims as to what is supposed to happen when these chemicals are combined. Fenter has used the word chilled because it ties in with a chilled methylamine that he says was found in my fridge. Again, Fenter is talking rubbish. In the world of chemistry, there is no reference to any chemical conversion that requires for methylamine to be chilled. Contrary to what Fenter is saying, exactly the opposite is required for conversions to take place. Heat and not cold will be required. Fenter included this adjective chilled because he wants it to be believed that the chemical was in my fridge for nefarious purposes. Fenter found nothing illegal in my home, and he has not any clue why any of these industrial chemicals were there. Relying on guesswork and grasping at straws, Fenter must use whatever he can to serve his malicious intentions to conjure me up as being a criminal. Fenter's wicked scheme performed well, and his clever inclusion of the word chilled really caught Trengrove's eye, and Trengrove couldn't help himself as he repeated Fenter's gobbledygook, where Trengrove repeats the word chilled no less than 3 times in one paragraph. Erasmus also highlights the word chilled in paragraph 14 of his judgment, where he says that Fenter found a flask containing a small quantity of what he has later established was chilled methylamine in the kitchen, which apparently is combined with 1-phenyl-2-propanone to produce methamphetamine. Erasmus has exposed himself with his employ of the adjective apparently, which is injudicious because it carries with it the element of doubt. Criminal convictions do not sit between something that might be or something that might not be. In violation of my right to a fair trial, Erasmus has clutched onto Fenter's lies to characterize me as being a drug-dealing criminal. In the judgment of the Supreme Court of Appeal, we see chilled appearing in paragraph 7, twice in paragraph 8, and twice in paragraph 20. In the Constitutional Court, the word chilled appears in paragraph 10G, paragraph 11, and again in paragraph 12. Fenter fooled everyone into falsely believing that the methylamine needs to be chilled when making methamphetamine, or we would not see this word appear as many times as it does. In paragraph 2, on page 3 of Trengrove's submissions, Trengrove affirms to the reader that he and the National Director of Public Prosecutions are describing the facts. At the top of page 4, Trengrove kicks off with the facts, which is typed out with bold print in capital letters. Trengrove was paving the way to pull the wool over the eyes of his audience, for them to accept without question and believe Venta's lies that Trengrove proceeded to spew forth. Trengrove has absolutely nothing tangible to support his slanderous statements that I manufactured methamphetamine, or even that I was able to have done that. And his defamatory charges against Alan Huebner were shown in the criminal trial to be baseless. Trengrove's submissions are not what he calls facts. Trengrove's submissions are false. And about the real facts that were brought forth in the second criminal trial, Trengrove says nothing. Without going into detail about just how many lies Trengrove presented that he referred to as the facts, let me not deviate from my criminal charges against Venta. In paragraph 52 of his submissions, weaving a web of lies, Trengrove harps on about Venta's 400 to 600 grams and Smith's 250,000 rand, which we know are definitely not facts. The 400 to 600 grams is an outright lie. Trengrove has engaged a legal fraud on the court by repeating Venta's lies and other lies emanating from Venta's lies as though they are facts. In paragraph 15 of his submissions, Wim Trengrove relied heavily on Venta's fables. By trailing behind Venta's lies, Trengrove lies to the court that I was interrupted by the arrival of police while I was in the process of manufacturing methamphetamine by combining 1-phenyl-2-propanone with chilled methylamine. And he goes on to say that the flask found in the fridge, which Daniels emptied into the kitchen sink, contained methylamine, which was being chilled for combination with 1-phenyl-2-propanone to produce methamphetamine. And then he goes on to say that the combination of 1-phenyl-2-propanone and chilled methylamine could only have been used to produce methamphetamine. By espousing on Venta's made-up stories as being true, Trengrove has entered into the criminal domain where the law does not allow for him to tread. Making a meal of Venta's lies, Trengrove has plunged himself into the unlawful deprivation of my property. And it is indeed true to say that liars and thieves work hand in hand. After watching this video, it is now known that key claims coming from Venta are malicious and dishonest. Trengrove has repeated Venta's lies to wrongly convince the courts that I'm a drug-dealing criminal. Venta's claims in paragraph 8.1 and paragraph 8.5 are not true. As a supposed to be expert, Venta would know that what he was saying is not true. But he was following an agenda, and by hook or by crook, he went out of his way and he told several critical lies about things that he said that he found to prepare an introduction about me to more easily fool the reader into perceiving me to be a criminal. Venta slyly maneuvered his story of intrigue, and his dirty scheme worked. Erasmus believed Venta's lies. The Supreme Court of Appeal also believed Venta's lies. And the Constitutional Court went along with the lies. I did expose Venta's lies to the Constitutional Court in an affidavit that had been prepared by Michael Allen Smith, a chemistry lecturer who had been lecturing on chemistry at a university level for more than 20 years. And the chemistry lecture exposes and explains where Venta has gone wrong. The chemistry lecturer tells us that you can't synthesize methamphetamine simply by combining 1-phenyl-2-propanone and methylamine because the compounds do not produce methamphetamine in one step. The chemistry lecturer challenges Fenter's paragraph 8.5 in that according to the chemistry lecture, the compounds 1-phenyl-2-propanone and methylamine can be combined under appropriate conditions, mind you, to produce the condensation product 1-phenyl-2-methyl-aminopropanone. Our real-life chemistry experiment, which has been performed in front of the camera, has demonstrated that what the chemistry lecturer tells us is in fact true, in that 1-phenyl-2-propanone and methylamine do not combine to produce any alternative chemical in one step. All that happens is that the oil-based chemical floats on top of the water-based chemical. It might be possible, as the chemistry lecturer tells us, to introduce and to use other chemicals and engage certain chemical procedures to get these chemicals to perform. But Fenter's inclusion of chilling down the methylamine is nothing more than hocus pocus. The chemistry lecturer provides us with a list of other chemicals that are required when following Fenter's lead. These unfound chemicals include aluminium, mercury chloride, methanol, ethanol, diethyl ether, sodium borohydride, H2 gas and palladium, H2 gas and uranium nickel, and sodium in ethanol. So many unfound chemicals plays havoc with Fenter's untrue volume concoction of 400 to 600 grams. In his affidavit, the chemistry lecturer's inclusion of and apparatus also disposes of Fenter's claim of being able to make methamphetamine, since Fenter, inside my home, is lacking all of the sophisticated equipment required to work under pressures as high as 1,200 atmospheres. 1-phenyl-2-propanone and methamphetamine boil at temperatures exceeding 200 degrees Celsius, which calls for specialized apparatus to protect these chemicals to prevent them from degrading into toxic substances when being distilled. None of the specialized equipment and apparatus was found at my home, which would disqualify any attempt on my part to complete the complicated process of making either 1-phenyl-2-propanone or methamphetamine. Unfortunately for me, the chemistry lecturer's affidavit did not protect me from Fenter's humiliating libel, and nor did it enforce or protect my right to the presumption of my innocence, because the Constitutional Court refused to allow me to submit this affidavit into the court. Michael Smith's affidavit presents inescapable problematic issues regarding Fenter's childlike hypothesis. In a criminal trial, Fenter does not qualify as an expert. In a civil trial, Fenter was allowed to qualify as an expert because, according to Erasmus, the rules of a civil trial differ from those of a criminal trial. But expert or not, Fenter, by falling over his own feet with all of his damning contradictions, has done himself the dishonor and the disfavor of having disqualified himself from even being allowed to be in a courtroom, much less to offer up his nonsense. The National Director of Public Prosecutions can bring however many experts it wishes to try to cover up for Fenter against what is revealed in Michael Smith's affidavit. But however many they may be, then let me say that none of them will convince me that Fenter has not contradicted himself in 1, 2, 3 instances that are brought to the attention of this court. There is no need to consult with chemical engineers who will disagree with Fenter, because Fenter's contradictions alone render Fenter's testimony as being worthy of impeachment of credibility. Contradiction number 1. In paragraph 6 of Fenter's volume affidavit, Fenter tells us that from the volume of chemicals found, that it was possible to synthesize 400 to 600 grams of methamphetamine, which to the diligent observer contradicts what Fenter unconsciously discloses in line 2 of table 1 on the same page, that it would not have been possible to synthesize any amount of methamphetamine, which unequivocally means that the malignant exaggeration of hundreds of grams are obviously all false. Contradiction number 2. In paragraph 6.2 of his impossible volume affidavit, Fenter tells us that 1-phenyl-2-propanone and methylamine react to provide us with N-formal methamphetamine, which contradicts what Fenter tells us in paragraph 8.1 of his false formula affidavit, where Fenter changes his tune to tell us that the two starting chemicals perform to produce methamphetamine. Contradiction number 3. After telling us in 2 different affidavits that there are 2 different resultant substances, Fenter then contradicts himself to say in paragraph 8.5 of his false formula affidavit that there can only be one resultant substance. Creating contradictory affidavits is a dangerous act that can result in criminal conviction, hefty fines, and potential imprisonment. Fenter has never been a witness to any wrongdoing on my part, and the entirety of his false allegations against me are not only wild, but also impossible speculations conjured up by Fenter's imagination to portray me as a criminal so as to provide the National Director of Public Prosecutions an opportunity to determine exactly to how far it can go to be able to unlawfully engage the Prevention of Organised Crime Act. I have never been involved with any organised crime, and I have never entertained any intention of such criminality. Wim Trengrove, in the employ of the National Director of Public Prosecutions, has paraded himself before the judges wearing garments dripping with Fenter's lies, and after my acquittal, Trengrove has unlawfully, in a constitutional court, slandered me in front of the whole world. There's no escape for Fenter with his contradictions, and his impossible proposals point to and prove grave misunderstandings regarding Fenter's speculation. What has been presented in this video is undeniable, and it proves fraud on the court. Fenter, with his multiple contradictions and his lies, has disqualified himself as a witness against me. Adding on to the lies coming forth from Fenter, we must not overlook other contradictions emanating from Johan Smit and Rian Redlinghuis. Contradiction number 4. The fourth contradiction is the Redlinghuis false claim of 1 kilogram, which contradicts Fenter's volume claim of 400 to 600 grams. Contradiction number 5. The fifth contradiction is Redlinghuis's false value claim of 700,000 rand, which contradicts Johan Smit's false value claim of 250,000 rand. Contradiction number 6. The sixth contradiction, if you stop to think about it, is that the Redlinghuis claim of 1 kilogram also contradicts Fenter's unconscious revelation that no methamphetamine could have been manufactured. It is against the law to punish innocent people, and the National Director of Public Prosecutions has broken the law of Section 10, Section 35(3)(h) of the Constitution to proclaim to the world that I'm a drug-dealing criminal both before and after I've been found to be not guilty. The National Director of Public Prosecutions has broken the law of Section 12.1d and 12.1e of the Constitution, and by abusing its authority, the National Director of Public Prosecutions has unlawfully manipulated the Prevention of Organised Crime Act to torture me and to dehumanize me by treating me in a viciously cruel and barbaric way to engineer that I be cast out of my home to go and live in the street. Anyone who thinks that what has been done to me complies with constitutional law, they have lost not only their humanity, but they've lost also their divinity. And the next step for them, if they're not already there, will be satanic ritual and human sacrifice. By fooling the courts through a legal fraud, the National Director of Public Prosecutions has achieved to violate Section 25 of the Constitution by improperly enriching itself, by depriving me without compensation of my property, my shop, and the fruits of my life's labor. After the presentation of this video to the proper authority, there can be no other reasonable outcome but to rescind the Erasmus judgment.